From the state of Minnesota, the Voluntary Investigation and Cleanup Program, Kenneth Haberman and Alan Williams.
Thank you. My name is Alan Williams. Minnesota's Voluntary Investigation and Cleanup Program is based on two innovations in the way that the Minnesota Pollution Control Agency and the Attorney General work on environmental problems. First, we have departed from our usual regulatory and enforcement roles and instead provide a service that includes technical review and assistance with a problem-solving approach to the legal issues. Second, we have selected a goal that makes economic development a partner with environmental protection. Our goal is to encourage reuse of polluted property. We created the VIC program because we saw that buyers, developers, and lenders were avoiding polluted property due to unknown cleanup costs and risks of future liability. This inhibited investment and redevelopment in our older communities and pushed new development into green fields on the outskirts of the towns and cities. These negative effects on the real estate market and community redevelopment were often blamed not on the pollution, but on our tough state cleanup laws that are essential to get major polluted sites cleaned up. So we created a program to encourage businesses, local development authorities, and others who became the clients of this program to volunteer to investigate and clean up properties they wanted to purchase or develop. We did this by offering technical guidance to help our clients identify cleanup options and to quantify their costs and their risks. This includes legal assurances to help minimize risks of future cleanup liability. We were able to create this program for several reasons. First, we started small and we built on our experience. We began with a very simple 3-sentence law, and we learned case by case what it would take to get people to volunteer to do cleanups. Second, we concentrated on problem solving rather than finger pointing. We developed a consensus for our program and for additional legislation through several forums, especially the Legislative Commission on Waste Management. This was capped by the passage of the Land Recycling Act in 1992, which codified much of our program, extended express liability protection to certain cleanup volunteers, and gave us additional staff to respond to our clients' needs.
Our clients are a diverse group with many needs, and I want to touch on just two of those needs right now and what we've done with them. First, our clients need a well-defined, streamlined, yet flexible approach to conduct investigations and cleanups. To this end, we've developed 18 guidance documents which serve as roadmaps to help them in the remediation process. As an example, in 1991, a company located in a small town in central Minnesota was planning to close and move out of state. Mr. Terrell Stern proposed to purchase the property. However, the discovery of solvent contamination threatened the financing. Mr. Stern entered the program, and within 4 months, cleanup plans were approved and implemented in time to save 80 local jobs. A second need our clients have is to receive written assurances and approval, an official sign-off, a sign-off that provides closure and a sense of comfort. In response, we developed a menu of written assurances that provide liability protection when the technical and environmental requirements are met. And let me cite another example. For years, an area in the riverfront property of Minneapolis, long used by industry, sat idle. The City Development Authority purchased the property, entered the program, and completed a $1.3 million cleanup. We then were able to issue a certificate of completion, just the type of assurance needed for the construction of a $12.1 million townhouse. To date, 428 projects have entered the program. Nearly half of them have been completed, resulting in almost 2,000 acres of property being put back into economic use. Our clients have discovered that the successful participation can be a positive public image. In addition, they've discovered that the staff are responsive, goal-oriented, cost-conscious, and creative. Components of our program have been replicated in other states, including Maine, Wisconsin, and Oregon. And Minnesota has been a leader in advising the U.S. Environmental Protection Agency and Congress on how voluntary cleanup principles should be incorporated into federal Superfund legislation. Thank you very much.
Thank you both. Luis, first question.
Are you able to give assurance with regard to federal liability?
No, we're not, and that is one of the issues that is sometimes an obstacle for us. We spend a lot of time talking to lenders and their attorneys about that issue. Basically, we say that most of the sites that people are interested in redeveloping are not national priority list sites. They're not sites that the EPA at the federal level is going to initiate enforcement on. We tell them that Minnesota has a strong state Superfund program that is the lead agency for all of the non-national priority list sites in Minnesota, and that when they get the word from us, in a practical sense, if not in a legal sense, they can feel secure.
What percentage of the cases that you deal with are affected by potential federal liability questions?
All of them. Because federal liability, the way that the law is written at the federal level, any release of a hazardous substance could be covered. But in practice, the National Priorities List contains 1,200 sites nationwide, and those are the sites that the EPA is primarily concerned with.
Don?
In a previous competition, we had a similar program from a city of Wichita, Kansas. I wonder if you could, because I remember that one fairly well, could you differentiate the program on the state level that you have from the city program in Wichita?
I'm not very familiar with that particular project. One of the differentiations, I think, is similar to what Alan was talking about. I believe Wichita looked at one city, multiple sources. One of the differences is that we deal with properties that may not need a cleanup, that the contamination after investigation results in no cleanup at all. That then, at least for the parties involved, they have the assurances that they don't need to go on.
Harriet?
What are the elements, do you think, I mean, in terms of looking at other states doing this and their capacity to provide confidence that the appropriate safeguards will be there? I mean, it's not just the program, obviously. You know, there are all these other requirements for the Superfund, and yet you're doing something effective. What is it that you're doing that has to be part of that program? I don't know how else to phrase it.
One of the things we often hear, and as Alan indicated, it was kind of an evolutionary process that led to statutory authority. Our legislature was very proactive in enacting laws so that when the sign-offs came, they weren't simply sign-offs from the commissioner of the agency or a staff-level person. It was already in the law. And a number of states are doing that now, enacting the legislation so they can issue the different types of assurances.
I would also emphasize that before we had this program, we had 5 years of experience with a very strong state Superfund program. So we had developed the technical expertise in dealing with the bigger sites. We knew what the standards needed to be, and we were then able to kind of translate that, streamline that process, but still get a result that met the standards that we had developed.
One last question from Max.
One of the new tools that you have is called a certificate of completion. How has that, and that's only been used just in one or two instances as I understand it, how has that tool been accepted by the environmental community?
The certificate of completion is the prime sort of sign-off, because in that certificate there needs to be a full investigation, there needs to be a cleanup conducted, and that's one of the assurances that's in the statute, the Land Recycling Act, and so the community has accepted it very strongly.